Hello guys, welcome back to my channel. I am Shaunette Stokes, managing attorney at Stokes Law Group. Today we're going to talk about registering your trademarks the celebrity way. So let's get started. I'm going to do my makeup while we chat. Today I'm using the One Size Secure the Sweat primer. So have you ever wondered how these celebrities register their marks and then launch their product? Let me tell you how. Have you ever heard of the saying, Lil Wayne said it, real G's move in silence, right? Well, that is what celebrities do. What they do is they'll get with their marketing team and they'll come up with a brand name for their product. And guess what? They will register that trademark. And I know that you've heard that you have to have the product or service in hand for you to have a registration. That is in fact true, but you can start registering your product or service before you even launch it. I'll tell you how in a moment. Today, we're gonna use the Fenty's new Naturally Luminous Longwear Foundation. I am the shade 370. Let me find my brush. Just use this much. There. So when it comes to celebrities protecting their brands, they're very mum's the word, okay? They do not put out their brands to the public because guess what? There are thieves on the internet. You have people that will take your idea and run with it. And the sucky part, shall I say the sucky part about trademarks is the person that is first to file their registration has priority within the USPTO's system, their database, their office, you name it. I always liken this process to the DMV, right? Whenever you're going to the DMV, you want to be first in line because you want to be seen first, right? That's the same when it comes to registering your trademarks. You want to register it first before any competing person or business registers a similar mark. So when you come up with the concept, you want to file the application. I always tell my clients, before you launch, file your application. Before you put it out there, file your application. And the way that you do it is that you file the application as what we call a 1B filing, and it's the intent to use application. It's the same process as the trademark registration process if you already are in business, if your product's already in the marketplace. Except in this case, the process is kind of reversed. So I'll go through the timeline with you. After your attorney files the application as a 1B application, which means that it's intent to use, it will sit for months. The USPTO is backed up. And when I tell you backed up, they're backed up, okay? What used to be a 3-month wait back in the day, and when I say back in the day, about 10 years ago, is now a 9 to 12-month wait for it to even get to an examiner. So with the same example of going to the DMV, you're sitting in the waiting room. Imagine sitting in the waiting room for 9 months. Insane. So you're sitting and waiting for your trademark application to get assigned to an examiner. And after it's assigned to an examiner, then the examiner will go through a process, I hope the same process that your attorney went through, which is they will conduct research and search their entire database to determine whether or not your mark is similar to other marks within the USPTO's database. And then they will do a legal determination on the strength of the mark. So it's a two-pronged test. It's whether the mark is taken or whether it's strong enough to be a valid trademark. If you have a good attorney, your attorney will tell you. And there are some instances where your attorney may have a difference of opinion with the examiner because we have, and I tell my clients all of the time, that the examining attorney at the USPTO, they're supposed to assert a legal opinion on the mark. most often they assert a subjective opinion. And it's up to your attorney to essentially convince the examining attorney that their opinion is wrong. So it's essentially two attorneys going back and forth, having a difference of opinion, and whoever has the better argument wins. Which is why you should get an attorney to register your trademark. Those applications look so easy, but the legalities surrounding registering a trademark is very complex. It's not a bright line rule on how a trademark can be registered. You should get an attorney. Going back to the process, make sure my face don't look like, okay, girl. Jesus, hold on. Make sure we dusty and crusty up top. So going back to the actual trademark process, if you're filing any application, be it a 1A, which means that the application is already in use, or a 1B application, which means that you intend to produce the product or offer the service in the near future. And generally the near future would be within the next year or so. With that being said, you will file your trademark application and your attorney will indicate whether or not it is a 1A already in use, which means that you have to provide actual specimens of use, meaning that you are actually selling this good or service across state lines, which means in commerce to your consumers. Or you can file a 1B application, which means that you intend to market this in the near future. Once you file those applications, be it 1B or 1A, I am using the NARS Praline concealer. And then I'm gonna use the Too Faced Butterscotch concealer on the inner corner. Once the application gets filed, as I said, it's pending for a good 9 months. And then it finally gets assigned to an examiner, and the examiner will render their initial determination. They'll do their assessment, and then they will submit what we call an office action to the attorney or to you if you are filing on your own, which I highly don't recommend. Once they do that, you have 3 months to respond. It used to be 6 months, but we're not going to talk about that. The USPTO likes to change a lot of stuff, okay? Overnight. I digress. I gotta focus. Chin. Forehead. I look like Dwight right now. And who is Dwight? The white around my mouth. That was so corny. Anyway, back to the subject. After it gets assigned to an examiner, then the examiner goes in and makes their initial determination of the eligibility of the trademark, and then they will issue an office action or shoot it to the next phase, which is what we call publication in the Official Gazette. What is the Official Gazette? I will tell you. The Official Gazette is essentially, it's like, you know, when people get married and you have the couple is at the podium and the pastor says, is there anyone here that objects to this union? Speak now or forever hold your peace. And that's essentially what the Official Gazette's purpose is. It's putting the entire world on notice that this company is filing a trademark in this name. And if there is a company out there that generally has trademark watchers on, like the larger companies will have a trademark watcher, or they'll have their attorneys watching the trademark database to determine whether or not there is a company out there trying to use a similar brand name as theirs. So what happens in these cases is the trademark attorney for the company that feels as though the pending trademark is too close to theirs, they actually will file an objection to that application. So then what happens is they'll pull it into what we call trademark litigation, but not on the federal side. It's more on it's called the Trademark Trial and Appeal Board. So what that does is now you're having to defend the trademark against this company. And once you show, and that's also with most attorneys, an additional cost. And these are things that you can't control, unfortunately. But I always tell my clients, if you are in business, you have to have a budget for legal because you don't know if and when you're ever going to get sued. So you need to have a budget that is set aside for your legal fees. Once that application is published in the official gazette, and if someone feels as though you're using their mark, then they have the right to object to it. And generally, this happens 9 times out of 10. It honestly doesn't happen as frequently as you may think. So, especially if the examiner has rendered an opinion stating that there's no competing marks, if your attorney has also rendered an opinion stating a similar thing, then the odds are very slim. But sometimes you will have situations where a third-party company, thinks that this is too close to theirs, and they will fight you. But if they don't, then after it's published in the official gazette, then if you filed a 1A, meaning if your company has already been in the marketplace, then you get your registration certificate. So if you filed a 1A and it goes through the official gazette without any objections, then you get your registration certificate within a month or two of it being published in the official gazette. And it sits in the official gazette for 30 days. Once you get that notice that it's been published and it's going to be published on this day, you can expect to receive your certificate 30 to 90 days after the publication date. They are very slow. We're dealing with the federal government, so just bear in mind. Then, if you filed a 1B application, then what's going to happen is they're going to issue a notice of allowance. And a notice of allowance essentially says that we have processed your trademark through the entire trademark process. We have published it. No objections have been made. You're good to go. You are allowed to use this mark. You have to pay the USPTO $100 to file what we call a statement of use. And the statement of use has to be a legally acceptable specimen. And again, which is why you need to hire an attorney, because an attorney knows what the legally acceptable specimens are. So it has to be a legally acceptable specimen showing that your mark is in commerce. And once you filed your statement of use, after the notice of allowance has been issued, and if they accept it, then you get your registration certificate. And that, my dear, is how these celebrities are able to get their protection of their trial. They are launching their product, because what they're doing is all of the legal requirements are the necessities to protect their brand on the back end. And they're making sure that once they launch their product, that the USPTO has given them the green light to actually move forward. So being given the green light by the USPTO covers 2 things. One, you know that you were first in using this name and you have the exclusive right to use this name. 2, once you know that you've been given the permission to use your mark and gotten the notice of allowance, you can now have the comfort in knowing that when you launch your brand, that no one is going to come to you and say, hey, this is my brand name. Because if they don't have a federal trademark, then the only thing that they can do is sue you on the local level. And that's a whole nother conversation for a different day. We'll talk about common law trademarks versus federal trademarks, because it becomes very nuanced when you have a federal registration and federal protection over common law protection. So we'll have a different video for that. But today I wanted to cover how celebrities are able to get their products registered or services registered before they even launch it. And that's how they do it. As a business owner, when you decide to come up with a name, you want to make sure that you file for the trademark first, because that gives you the freedom in progressing in the marketing plan and the launch plan of that product or service. Right now, I am using the Charlotte Tilbury Girl, I do not know what this is. but I'm setting my eyes with this so that there's no creasing. And next, we're going to go in with the Huda Beauty. I am using peach pie. I'm gonna bake with this, but I'm also gonna set my under eye with it as well. I don't know if I like this case. Jesus. This is also going to brighten my under eyes. Doing a little reverse contouring. I actually am using the One Size Sweet Honey. Child, when they say bacon, you really look like you doing something. Bacon or, this is a family-friendly channel. So after you've gotten your trademark certificate, now you're ready to enforce your rights against other parties infringing on your marks. I always tell my clients, do not send a cease and desist letter to anyone when you do not have a registered trademark. Because what can happen is they can file a registration before you. And if they do, then they are considered priority. So you want to make sure that you have the rights federally, not within the state, to assert any claim against anyone for infringing on your mark. Now, there's a caveat. If someone is infringing on your mark, so I just baked, we're gonna go in and add back some dimension with the bronzer Sunstalker Coco Naughty. Fenty is my gal. So some color up in here, child. So if there's someone using your mark in the same state as you, then my recommendation has always been, and by the way, this is not legal advice. I am not your attorney. I am just an attorney on the internet. So before you go and do anything that I tell you to do, go find a lawyer and cross-reference what I'm saying with their legal advice, because you have not hired me. Therefore, we do not have an attorney-client relationship. But if there's someone in your same state using a very similar brand, I always tell my client that if you see someone, and people do this often, if you see someone using your brand, register it first, have it already pending before the USPTO, because I've seen where people have sent a cease and desist letter, and then that person received the cease and desist letter, checked the USPTO's database because they have a little bit more knowledge about trademarks than that other person does, and they filed the trademark first because they know that if they file the trademark first, they are considered priority over that person. You want to make sure that before you send a cease and desist letter to them, you already have something in the works of protecting your rights. Now, if you're both in the same state, you are very much so eligible to send them a cease and desist letter. But again, your trademark should be pending before the USPTO before you even decide to do that, right? Because as I said, real G's move in silence. And if they see that you are not pending before the USPTO, they can for sure file an application. Now, granted, there's a lot of fraud that happens against the USPTO. There are a lot of people that are filing trademark applications where they say that they are in business and they have been in business before a certain time period, and they haven't. And it does take a lot of time and money in litigation fees to prove them wrong. So I always tell people, preventing all that, just register your trademark. You don't want to have someone file their trademark before you have even gotten to do that. Two things. I have this One Size Beauty fat ass. Every time I use it, child, I look like a clown. But this is a great, I don't even drink soda, guys. Oh no, oh no. This is Rare Beauty Love. I love it. And it is a liquid blush, and it's probably the best blush I've ever. Jesus, I'm crazy. Probably because I'm talking too much. It's the best blush I've ever used. Put that crease, child. Anywho, the moral of the story is real G's move in silence. If you want to protect your brand with the least amount of drama, you're going to do it without sending cease and desist letters before you even have the legal right to enforce someone from using your mark. You're also going to make sure that you make the determination whether or not you're going to file a 1A application, which is actual use, or the 1B, which is you're intending to use the mark within a year or so. And once you make that determination and have filed the trademark, then is when you can start making plans with launching your brand, marketing your brand, and potentially even if you haven't launched a brand, you can't send a cease and desist letter because you don't even own it yet. Don't do that. But it looks like it's not enough. Watch me put some more on here and start looking like a daggone client. But if you're already in commerce, if you've started using the brand and you've put other people on notice by publishing your marketing and you have filed the trademark, then you are free to send a cease and desist. But again, hire an attorney. You don't hire an attorney, you're probably going to make matters far more worse than they could be had you hired that attorney to begin with. But again, seek the advice of an attorney first before you proceed with action. Always, always, always hire an attorney. If you are a business owner, have a budget for an attorney. Always. Now I feel like I look like a clown. So we're gonna put this. I always use the one size ultra pink when I OD on blush. I feel like it dials it down just a little bit, just a touch. I hope this video resonated with you. If there are other topics that you want me to speak about, feel free to comment or send me a DM letting me know that you want me to speak on a certain topic, and I'm more than willing to do that. I do respond to my DMs. It may not be on time, but I respond nonetheless. What we're gonna do, I actually do like the highlight on this. We're gonna use that highlighter. Okay, we're gonna do these brows. Shout out to my brow girl. Let me tell you, every time I do my makeup, I'm so thankful to you. Her name is Gigi. She kills it. Before I met her, I was a bald-faced baddie. And now, girl, I got brows. She does ombre brows. She does microblading. These are ombre, I believe. And when I put on makeup, all of the foundation kind of overpowers the ink. So I just gotta go in just a touch to darken it a little bit more. But baby, I wake up and go when I have just a regular face, no makeup. I still got my brows, boo. Thank you, Gigi. See that? Quick. We're winning. Ooh, child, let me not show no shots on Beyonce's internet. She would not approve. I think that we're good. We have the brows done. My lashes are already lashed. I'm just taking a little bit of the Fenty 370 Pro Filter, just going over a little bit in areas that I feel like I OD'd on. And then we're good to go, baby. And now we're about to OD again because I am going to use the Prep and Prime Fix It, then Charlotte Tilbury Airbrush Flawless Spray, and then one size. If I'm going out, I would also add this. But we're not doing all that. Wanted to come back and just show y'all the lipstick or the lip combo. So I'm using the NYX NYX Cocoa, and I found this Floss Bomb in Ruby Milk. I don't think that she sells it anymore, but it's Ruby Milk. And this is my face for the day, and I'm about to get ready. That's it, guys. Thank you so much for joining me in another Get Ready with Me. I hope that the information I gave you helped you a lot. And again, I am not your attorney. I'm just an attorney on the internet. Please seek the legal advice of an attorney. If you need legal advice from my office, you may always call us at 813-444-4156. We accept trademark clients from the entire nation. So we are open to new clients. If you need the advice of our staff, feel free to contact us. I look forward to catching you in the next video. Bye, guys.